In 1993, Congress made huge improvements to the rights and flexibility employees enjoy in the workplace. The Family Medical Leave Act was signed into law, expanding the rights of employees to take unpaid medical or military leave for themselves or to care for qualified family members without the possibility of negative job repercussions. Employee rights continue to be expanded as the bill has seen updates over the years, most recently in 2015. While the FMLA is simple in its premise, the actual law can be quite complicated for employers and employees alike. Let's take a look and see if we can make some sense of it. It's important to note that the law only applies to employers who have 50 or more employees within a 75-mile radius and to all public employers and local public schools, regardless of employee count. Some states have also enacted laws of their own with different qualifying thresholds. In situations where state or local governments have enacted FMLA laws, the employer should follow the law that is most advantageous to the employee. Currently, employers in Maine, Maryland, Oregon, Rhode Island, Vermont, Washington, and the District of Columbia have such laws in place. To be certain you are current with state and local legislation and to remain compliant, stay mindful that laws are always changing. In order for an employee to be eligible for coverage by the Act, he or she needs to have worked for the current employer for 12 months and to have logged at least 1,250 hours during the last year. The 12 months of employment don't need to be consecutive. However, the 1,250 hours in the last year are required to be in consecutive months in order to receive benefits under the Act. Employees can take FMLA leave for themselves or for their spouse, parents, or children. The FMLA's definition of eligible spouse, parent, or child is as follows. Spouse. Spouse means a husband or wife as defined under state marriage laws and includes common law and same-sex marriages. In 2015, the law was amended to include same-sex partners. All legally married same-sex partners are now eligible under the Act. Parent. The FMLA uses the term in loco parentis to define parent under the Act. This means that any individual who provided day-to-day care or financial support to a child before his or her 18th birthday is considered a parent under the Act. This includes biological, adoptive, step, or foster, father or mother, or any other individual who stood in loco parentis to the employee when the employee was a child. This also means an uncle, aunt, sibling, or anyone else who provided the primary care and financial support of a child could be considered a parent under the Act. However, this term does not include parents-in-law. Son or daughter. Son or daughter means a biological, adopted, or foster child, a stepchild, a legal ward, or a child of a person standing in loco parentis, who is either under age 18 or age 18 or older and incapable of self-care because of mental or physical disability at the time that FMLA leave is to begin. This means that a parent may take leave for a child who is 18 years or older if that child is incapable of caring for his or herself. The FMLA mandates that an eligible employee can take up to 12 unpaid work weeks of leave in a 12-month period for the birth of a child and to care for the newborn child within 1 year of birth, including time for both mothers and fathers to bond with the child. For leave by mothers and fathers when a child is placed with the employee for adoption or foster care, and to care for the newly placed child for 1 year thereafter. For care of an employee's spouse, child, or parent who has a serious health condition. For an employee who is unable to perform the essential functions of his or her job due to a serious health condition. And for any qualifying exigency arising out of the fact that the employee's spouse, son, daughter, or parent is a covered military member on covered active duty. The law also mandates that up to 26 work weeks of unpaid leave can be taken during a single 12-month period for military caregiver leave to care for a covered service member with a serious injury or illness if the eligible employee is the service member's spouse, son, daughter, parent, or next of kin. During any serious health condition, military exigency, or military caregiver leave, the employer must provide employees the same health insurance benefits they would have been receiving while working. However, employees are still responsible for the same employee contributions they would have paid if they were still at work. No employee will accrue employee benefits like additional sick or vacation time while on FMLA leave. When an employee returns from leave, the employer must provide the same position or an equivalent one if the same position is not available. And the position should have the same pay, benefits, and responsibility as the employee's previous position. Provide full reinstatement of all employee benefits that were enjoyed before the leave, and provide protection from any retaliation as a result of the leave. The following are considered serious health conditions and qualify for FMLA coverage. A condition that requires an overnight stay in a hospital or other medical care facility. A condition that incapacitates an employee or the employee's immediate family member for 3 or more consecutive days and requires ongoing medical treatment. Chronic medical conditions that cause intermittent incapacitation and require treatment by a healthcare provider at least twice a year. Pregnancy, including prenatal treatment, morning sickness, and medically required bed rest. In situations when the employee does not take an extended leave of absence but continues to work during an illness, an employer must allow for intermittent leave for doctor's appointments and treatment. For example, an employee who is battling cancer might continue to work but may need to take FMLA leave several times a week for treatment or appointments. Employers are permitted to move an employee to an alternate position better suited for the need to take intermittent leave, so long as the new position has the same salary and benefits. A qualifying military exigency is for Reserve National Guard and certain retired military members, but not for active duty military members. A qualifying exigency includes one of the following: the need for any exigency that both the employee and employer have agreed upon, the need for up to 15 days leave to spend time with a family member who was on short-term temporary rest and recuperation leave during deployment, the need to address financial and legal arrangements pertaining to a covered military member's absence, the need to attend post-active duty military ceremonies, events, or programs, such as support groups for a period of 90 days. The need to attend non-healthcare provided counseling for oneself, the covered military member, or children of the covered military member, as long as the counseling is a direct result of the covered military member's deployment. The need to address childcare or school issues arising out of the active duty or call to active duty of the covered military member, such as providing childcare in emergency situations like a school snow day that normally would have been handled by the covered military member. Regular daily childcare is not covered. The need to address issues that occur due to a short notice deployment, a deployment with less than 7 days notice. As a general guideline, if the need for time off is a direct result of circumstances related to the covered military member's deployment, it should be allowed. For instance, a meeting at a child's school regarding academic or disciplinary issues directly related to a military member's absence would be covered. However, time off to attend a school play would not. An eligible employee who is the spouse, son, daughter, or parent of a covered service member with a serious injury or illness is eligible to take FMLA leave to provide care to that service member. Additionally, the military caregiver portion of the Act adds next of kin to the list. The next of kin of a covered service member is the nearest blood relative, other than a spouse, parent, son, or daughter, in the following order of priority: a blood relative designated in writing by the service member, blood relatives who have been granted legal custody of the service member, siblings, grandparents, aunts and uncles, and first cousin. To be a covered service member, the individual must be a member of the armed forces receiving medical treatment or therapy or recuperating from the result of injuries or illness incurred in the line of duty. Service members on the temporary disability retired list are also eligible for care under military caregiver leave. If the service member is a veteran, military caregiver leave must begin within 5 years of his or her discharge date. Veterans who have been dishonorably discharged are not considered covered service members. Employees must report FMLA leave 30 days in advance of taking leave unless the need for the leave is unforeseeable, like in the case of an accident or extended flu. In unforeseeable cases, the employee must report the need for leave as soon as possible, preferably the same or next day. When employees ask for leave, they must be as specific as possible so the employer can determine if the FMLA applies. Employees do not have to mention the FMLA by name. If an employee's circumstances fit the criteria for FMLA, then the employer must abide by the law. Employees have the right to take sick and vacation leave concurrently with the FMLA leave to help offset the loss in pay that they will incur. However, if employees choose not to take accrued leave as part of their FMLA leave, employers still have the right to require it. Employees must follow the employer's regular call-in procedures when taking intermittent FMLA leave. If the employee taking FMLA leave is salaried and among the top 10% most highly compensated individuals in the company, the employee may take FMLA leave. However, the employer does not have to provide a key employee the same or equivalent position upon return if doing so would cause substantial and grievous economic injury to the employer. The employer must inform the key employee in writing if he or she will not be reinstated and give the employee ample opportunity to come back to work. If the key employee does not return to work when notified, the employer must continue to provide the same health benefits until the FMLA leave is complete, upon which time the key employee still has the right to apply for reinstatement. Some of the major employer responsibilities under the Act include providing general notice to all employees by placing a notice of employees' rights under the FMLA in a conspicuous location like a break room or restroom, and by including FMLA rights in an employee handbook or by handing them out when employees are hired. Notifying employees of their eligibility status and their rights under the FMLA. Employers must notify employees when their leave qualifies as FMLA leave and how much time will count against their yearly allotment. Employers must notify employees of employer responsibilities under the FMLA. Employers must keep FMLA files separate from regular employee files. FMLA files must be secured and only disclosed on a need-to-know basis. Employers have the right to ask for a medical certification which supports the need for FMLA leave, provided that the request is made within 5 days of the employee's request for time off. A request may be made at a later date if the employer has reason to question the appropriateness of the leave. Employers also have the right to ask for second and third opinions. However, they must be done at the employer's expense. Contact the healthcare provider directly if they are given written permission by the employee and the person contacting the healthcare provider is not the employee's direct supervisor. Ask for additional certifications provided the length of time needed for leave stated on the original or subsequent certifications has expired and that they are not requested any more than once every 30 days. Ask for a certification once every 6 months, even if the current certification has not expired. Employees who do not provide a medical certification upon request run the risk of having their FMLA leave and/or job reinstatement denied. Light duty is a reduced workload position or a toned-down version of a job. Employers may offer employees the alternative of temporary light duty in lieu of FMLA leave, but they cannot require it. If light duty is selected, a list of an employee's essential job functions may be submitted to the employee's healthcare provider to determine the activities he or she may perform during the duration of the serious health condition. In addition, when an employee returns to work after FMLA leave, the employer has the right to ask that employee to work a light-duty job until fully ready to resume the equivalent or same position. Light duty cannot count against the employee's FMLA time. When an employee is returning from leave due to a serious health condition that left him or her unable to perform essential functions of his or her job, an employer maintains the right to require a fitness for duty certification from the employee's healthcare provider. The certification should indicate that the employee is fit to return to work. Such certification can only be requested if the following criteria are met. The employer has a uniform policy applied to all similarly situated employees, and the policy is in writing. The request is relative only to the serious health condition for which leave was originally taken. The employer may request that the certification specifically address an employee's essential job functions if, at the time of FMLA designation, the employer both indicated that this would be a requirement upon reinstatement and provided a list of the essential job functions to the employee. Employers generally may not request fitness for duty certification from employees who are returning from individual intermittent absences unless they believe a reasonable safety concern exists. Under this provision, an employer may request the certification up to every 30 days when there is belief that the employee presents a serious safety hazard to him or herself or to other employees. If an employee does not provide a fitness for duty certification upon request when the employer has met all proper conditions, the employee runs the risk of not being reinstated. Although cumbersome, the FMLA provides key benefits for both employees and employers. Employees have the ability to balance professional lives with personal and family health needs without the worry of losing their jobs during their greatest times of need. Employers, while assisting their well-trained and seasoned employees, enjoy the benefit of not only aiding in times of need, but of preserving their ability to maintain their most precious assets, their employees.